Hi guys, in this video I'll be talking to you about exclusion clauses. There are three key terms I want you guys to be familiar with. They are exemption clauses, exclusion clauses, and limitation clauses. Exemption clauses cover both exclusion and limitation clauses. Exclusion clause excludes liability for a breach of contract. And limitation clause limits liability for a breach of contract. For example, if you see a sign that says we exclude liability for damage to property, that's an exclusion clause. On the other hand, if you see a sign that says we limit liability by 10% or 20% for damage to property, that's a limitation clause. There are three ways in which a clause can be incorporated into a contract. So, by reasonable notice, signature, or previous course of dealings. Now, we'll look at a couple of cases. So, in order for a clause to be incorporated into a contract, it's important for the clause to be brought to the attention of the other party. So if a company is attempting to rely on a clause, they have to ensure that the other party is aware of the clause. So this was seen in Parker versus Southeastern Railway. A clause can be incorporated into a contract through various standard terms, such as a ticket, receipt, or a sign. In this case, the company Southeastern Railway, they had a clause on a ticket which limits liability by £10 to lost property or damage to property. When the claimant's bag got stolen, the company successfully relied on the clause that was on the ticket because it was sufficiently brought to the attention of the claimant. So the claimant was able to recover £10 in damages. Similarly, time of the notice is also important. This was seen in Ollie vs Marlborough Hotel. In Ollie vs Marlborough Hotel, the claimant contracted with a hotel so that the claimant contracted with a hotel to use one of the hotel rooms. Once the contract was concluded, there was a sign on the hotel room which excluded liability for any damages or lost property. Now, because the clause came after the contract was concluded, it was not incorporated into the contract. Therefore, it was ineffective. So even if the clause comes a minute or a second after the conclusion of a contract, then it will not be incorporated. Similarly, in Thornton versus Shoe Lane Parking, the car park had a machine which was an offer. The claimant, Thornton, accepted the offer by being there, by getting the ticket. So because the ticket came after the contract was concluded and the ticket contained exclusion clause, it was not incorporated. And again, the clause came after the contract was concluded, because even if it was a minute after, it will not be effective. So when the claimant was injured, he was able to sue successfully and claim damages. The form of the notice is also important, and this was seen in Chapelton versus Barry, 1940. In this case, claimant got 2 tickets and 2 deck chairs. As he sat on one of the deck chairs, it collapsed and the claimant got injured. And on the ticket itself, there was an exclusion clause written in small print, excluding liability for personal injury arising from the deck chairs. Now, the clause was not incorporated into the contract. It may seem as if though it was incorporated because it was printed, it was on the ticket itself, but it was not, because a reasonable person would not expect a ticket or receipt to contain a clause. A reasonable person would think that a ticket or receipt would contain a purchase information. So when you buy something from, let's just say, Tesco or Asda, if you get a receipt, you wouldn't expect the receipt to contain a clause. And so that's why the courts applied the objective test here, and held that a reasonable person would not expect the receipt to contain a clause. Another method of incorporation is by signature. Where a document is signed, the contents of the document becomes binding, and the parties signing the document will be bound by the contents of the document. This is known as the rule in Lestrange versus Gracov. So in this case, the claimant bought a vending machine which then happened to be defective. When the claimant tried to return the vending machine, the claimant was not successful because the claimant had signed the document, which meant that the claimant was bound by what was written in the contract. However, if the clause is misrepresented, then it will not be incorporated into a contract. So even if the claimant signs it, but if the clause is misrepresented, then the signature will not be effective. This is seen in Curtis vs. Chemical Cleaning, where the claimant took her wedding dress to a cleaning, and the defendant asked the claimant to sign a document which contained a clause. When the claimant asked what the clause was about, the defendant said, "Oh, we exclude liability for damage to the beads or the sequins on the dress." But when the claimant's dress had a stain on it, the defendants tried to exclude liability by trying to rely on the signature. Now, this was not successful because the defendants misrepresented. So when the defendants tried to exclude liability by relying on the clause, they were not successful because the clause was misrepresented to the claimant. So if the clause stated that the liability will be excluded for stain, sequin, damage to sequins or beads, then it would have been incorporated into a contract. So finally, another method of incorporation is previous course of dealings. So if companies have dealt, on the standard terms previously, then it will be incorporated into a contract. So if a company gets another company to sign all the time, and in one occasion, the companies did not exchange signature, then the courts will then decide was the clause incorporated into a contract by previous course of dealings. This was a case in Sperling versus Bradshaw. So in Sperling versus Bradshaw, defendant delivered barrels of juice, and claimants, they were warehouse men. So as you can see from the diagram, the defendant, they had a clause, they sent a clause which excludes liability arising from negligence. When some of the barrels were empty or damaged, the defendants successfully relied on a clause, and the clause was incorporated into a contract because the clause was incorporated through a previous course of dealings, and the claimants admitted that they knew that there was a document which contained a clause, but they didn't bother reading it. So it was basically the fault of the claimant for not reading the clause. So it was incorporated here. Another case we'll look at is Hollier versus Rambler. And in this case, the claimant took his car to the car repairers, which were the defendants, and the car was damaged by fire, which was negligence of the defendant. Now, the defendants attempted to rely on a clause by a previous course of dealing. So in this particular occasion, at this particular occasion, the claimants did not sign anything. So the courts then had to decide, was the clause incorporated through a previous course of dealings, which was not, because the clause covered damage caused by the state of the premises, but not the damage caused by the negligence of the defendant. So it was not incorporated, and the claimants were able to claim damages. And another thing we will look at is the Contra preferentem rule. Contra preferentem rule is construed restrictively against the party seeking to rely on a clause. Now the courts will ask themselves a question: does the clause cover the breach? Now, many bigger companies will try to use ambiguous wording and use harsh wording on smaller companies. So the courts will then use a word less favorable and then decide if the clause covers the breach itself. We looked at Holly vs. Rambler just a minute ago, and the Contra preferentem rule was seen in this case. So in Holly vs. Rambler, like I said, the claimant's car was damaged, and the courts then had to decide whether the clause covered the breach itself, which did not, because the clause covered damage to the car by the state of the premises, but not the defendant's negligence. Therefore, it was not incorporated. So in cases like this, the courts will apply the Contra preferentem rule and decide if it will be incorporated into a contract. Now, when you face a question, or when you think the Contra preferentem rule applies, you need to ask yourself this question: does the clause cover the breach? Now we will also look at the Unfair Contract Terms Act 1977. So the Unfair Contract Terms Act 1977 controls exemption clauses. Like I said earlier, exemption clauses are exclusion and limitation clauses. So Unfair Contract Terms Act 1977 controls exclusion and limitation clauses for breach of contract where one of the parties are a consumer. Now, Section 12 of the Unfair Contract Terms Act defines the consumer as a party dealing as a consumer where they don't make the contract in the course of a business, and the other party makes the contract in the course of a business. The goods supplied are for private use, and it only applies if the buyer is a company. So by Section 2 of the subsection 1, you can't exclude liability for breach of contract, but you can't exclude liability for death or personal injuries caused by the negligence. Now Section 1 here defines negligence as failure to take a reasonable care when carrying out contractual duty. So negligence is defined in Section 1 of the Act as failing to take a reasonable care as to carrying out a contractual duty. Now, there is an exception. The exception is that by Section 2 of the subsection 2, liability for other than death or personal injury caused by negligence can be excluded if it's reasonable to do so. So the exception to the Section 2 of the 1 is liability can be excluded for anything other than death or personal injury if it satisfies the test of reasonableness. Now, by Section 3 of the Act, consumer contracts or dealing on one party's standard business terms, liability cannot be excluded for non-performance or performance of something substantially different to what was expected, unless again it satisfies the test of reasonableness. So we'll talk about section 4, which is here. I kind of jumped to section 6 before 4, so I'm going to cover section 4 and 5 and then talk about section 6. Section 4 deals with indemnity, and by section 4 a party will reimburse the other for any loss arising from a contract if it satisfies the test of reasonableness. So again, section 4 deals with the test of reasonableness, and under section 5, companies issue guarantees or guarantees of consumer goods, and exemptions or exclusion or limitation clause in contracts involving consumer guarantees are ineffective. So we will look at section 6 of the 1 now, subsection 1. So liability cannot be excluded for breach of implied condition as to the title in section 12 of the Sales of Goods Act 1979. I will cover Sales of Goods Act in a different video, so I'm going to quickly talk about the exclusion clauses in this video. And by section 6 of the subsection 2, liability cannot be excluded for breach of implied condition as to description, section 13, satisfactory quality, section 14 of the subsection 2, and fitness for purpose, section 14 of the 3, and by sale by sample, section 15 of the Sales of Goods Act 1979. However, by section 6 of the 3, liability can be excluded for breach of implied condition as to section 13, which is description, section 14 of the 2, satisfactory quality, 14 of the 3, fitness for purpose, and 15 by sample, under Sales of Goods Act if it satisfies the test of reasonableness. By section 7 now deals with Supply of Goods and Services Act 1982. By section 7 of the 2, similar rules apply to section 6 regarding goods transferred under Sales of Goods Act 1982. By section 7 of the 3, liability can be excluded for breach of contract regarding goods transferred under Sales of Goods Act if it satisfies the test of reasonableness. Now section 8 deals with misrepresentation. So contractual terms which seek to exempt liability for misrepresentation will only do so if it satisfies the test of reasonableness. The section 11 of the Act covers the test of reasonableness. So if you want to find out more about the test of reasonableness, then it will be found in section 11 of the Act. Now we will look at unfair terms in consumer contract regulation 1999. Now regulation applies alongside the 1977 Act. It does not replace it, it applies alongside, and the regulation deals with unfair terms in contracts, and it deals with parties involving suppliers, sellers, and consumers. Now consumers cannot act in the course of business in relation to the unfair terms in consumer contract regulation Act regulation 1999. So like I said, regulation apply alongside 1997 but does not replace it, and only applies to contracts made between sellers, suppliers, and consumers. Regulation defines a seller or supplier as a person acting for the purpose of his business or trade. Consumer under the regulation is different to the consumer in 1977 Act. Consumer under the regulation is a natural person, whereas in the 1977 Act a consumer could be a company. Consumer under the 1977 Act is somebody who acts for the purpose of the business. Consumer can be for the purpose of the business or purpose of the consumption or private consumption. Now, the unfair terms in consumer contract regulation render ineffective certain unfair terms in contracts between sellers, suppliers and consumers. So this was found in Regulation 4. By Regulation 5, contract not individually negotiated, which should be regarded unfair if contrary to the requirement of good faith, and it causes a significant imbalance in parties' rights and obligation arising under the contract to the detriment of the consumer. So by Regulation 5 of subsection 3, which applies to parts of a contract not individually negotiated. Under section 6 of the 2, where terms are in plain language, the fairness will not relate to core contractual terms, and the adequacy of the price for goods and services provided. So if a term is regarded unfair under Regulation 8, the Regulation 8 provides that it's not binding on a consumer, although the rest of the contract will be effective without the unfair term in it. Now Schedule 2 sets out terms that may be regarded as unfair. So with Unfair Contract Terms Act, the burden of proof is on the party claiming that the exemption clause is valid. They have to show that it satisfies the test of reasonableness. Whereas under the regulation, the burden of proof is on the consumer to prove that the term is unfair. Now, under the unfair contract terms, the terms can be enforced by the parties, whereas under the regulation, by parties or by enforcers such as the Office of Fair Trading. This is my first video. Sorry if the quality is bad, and I will try to improve it for the next video. I hope you guys will learn something from this, and thank you for watching.